The number one mistake that I see people make is that they don't have a plan in place. And when we don't have a plan in place, the state of Ohio is going to substitute its judgment for your own. So what does that mean? That means that we need to think about the probate court, the cost of that, the delays that are involved in that, and also that the state of Ohio has said what your plan of distribution is, and that may or may not match what you actually want to have happen. So let me give you an example. We're going to talk about Bob's farm. Bob and Mary have been married for 30 years. They have 4 kids, and they have a farm that's, 3,000 acres. One of their sons actually rents out a portion of the farm from them. So he has a neighboring farm, and he uses a part of Mary and Bob's land for his own business. Whether or not he pays rent is not really clear, but we do know that they have an agreement in place that their son is for sure farming a portion of their land. They have a daughter who lives out of state, very much loves her parents, but can't stand the farm. We have a third child who also loves his parents and his siblings, but he's really bad with money, and he is always in need of quick cash. He calls mom and dad for loans all the time. He bothers his siblings for stuff when he thinks he can. And then we have our fourth sister, who she's super laid back. She's been taking care of her parents for years. She's their healthcare power of attorney. She's their financial power of attorney. And it is really important to her that the family remain intact at the death or disability of her parents. So let's fast forward a couple years on what happens on Mary and Bob's farm. So Mary passes away, and now Bob is single. So oftentimes I see in families is that there is a long-term marriage and one of the spouses passes away, and the surviving spouse doesn't take the actions that they need to protect their estate going forward. And one of the reasons is because they're in grief. They've just lost their longtime partner. Another reason is that they might not understand that they're single now. And so we have some protections in place as a married couple. They're pretty limited, but often at the death of the first spouse, the actions that you take through the court process aren't really complicated, if at all. But we have to be thinking about the fact that dad is now single. And so what does that mean for his farm? What's that mean for his family? What's that mean for the documents that he has in place now to help protect himself and the assets that he wants to pass on to his children? So Mary is now gone, and Bob does not take the steps that he needs to protect the farm and to protect the rest of his assets that he has. He does make a new power of attorney, and he does make a new healthcare power of attorney, which those are 2 different documents. We have a healthcare power of attorney and we have a financial power of attorney. So he does appoint agents to make decisions for him. If he hadn't, we're going to talk about that separately, but he does have those plans in place. But how are we dividing up the farm at Bob's death? So if Bob doesn't have a more comprehensive plan in place other than a fourth to my 4 kids when I die through the probate court process, then what we're going to have to do is gather up the farm. We're going to have to sell it off and then divide the proceeds, a fourth to all 4 of those kids. We're going to have to put this through the probate court process. Probate court process is going to take a minimum of 6 months, but when we're selling something like a farm, it's easily going to be a year and a half, 2, sometimes 3 years before anybody is going to see any of the benefit from the estate. In the interim time, we have the brother that's using the acreage, that he's in a panic because this was a significant part of his business. We have the other brother who's kind of pestering everybody for money because that's kind of what he does. But there's no payout anymore from mom and dad. And there's no Bob and Mary are gone and they're not giving him any money anymore. We have sister out of state who, loved her parents, but really not super involved in this process. And then we have the sister who's keeping it all together. So she is trying to categorically go through the house and gather up all the assets and find where everything is at. Fourth sister is trying to carry out her parents' wishes, which she is guessing mostly on what these wishes are, or she's using what she thinks her judgment should be in this situation because there was no clear plan communicated. So you can see very easily how quickly things can go off the rails in this situation. We have one little drop of fact change here, and our scenario is now in litigation. We now have a lot more delay and we have a lot more cost involved than if Mary and Bob had made a very clear plan right from the start that avoided probate and very clearly said what happens to their farm, what happens to the things in their house, and what happens to their financial accounts. So with simple planning that carefully takes into consideration what a family needs and the unique circumstances of that family, you can avoid almost all of the costly delay of probate. And the state of Ohio has not substituted its judgment for yours. It is your wishes and your loved ones that actually get cared for in the plan. If you want to take the steps to protect yourself and your loved ones today, the first step to take is just to start. You can visit our website at boonelegal.com if you'd like to learn more about our services, or you can give us a call at 330-968-6003 to schedule your appointment today.